Welcome to the Smithfield Planning Board meeting for Thursday, July 18th, 2024. Initially, in terms of emergency evacuation, in case of emergency, there remain two main exits out the chamber. The first is to the left side of the stage, up the stairs, through the doorway and down the stairway, out the back side of the town hall. The second is out the back of the chambers to the exit doorway, to the stairway, out the front of the town hall. The men's facilities are through the back of the chambers, past the stairway, around the corner on the right. The ladies' facilities are through the back door of the chamber, straight up the stairs and on the left. Please do not use the elevator in times of emergency. First matter of business is consent agenda, reviewing the meeting minutes of June 20th, 2024. Any discussion, potential revisions or changes regarding the June 20th meeting minutes? Not hearing any discussion. Do we have a motion?
Motion to approve.
All in favor? Aye. All not in favor? The ayes have it. Regular agenda, old business, Kleins 29 East Prospect, ID 2402, public hearing for unified development. Come forward. If you could state your name and your address, please.
Kevin Kleins, I live at 46 Burnett Road in Warwick.
Good afternoon.
Oh, yeah.
Good.
Good. I've been to planning department and to try and subdivide the lot that I have there. The lot from when the house burned down before, they already brought in easement, so they're expecting expansion over there beyond what was there. During all the planning meetings, we've met with the fire department, upgraded, built a cul-de-sac on my land to make sure there was room for emergency access and turnaround. If you come to the end of 29, am I going too fast?
Hold on. You need to straighten.
Oh.
You're gonna start over.
Okay.
Okay,
Yes.
I'm gonna explain exactly what your project's about. This is a recorded matter.
Okay.
So it has to be clear, we're talking one at a time, so the court reporter can take everything down properly and make an accurate representation.
Okay, so we'll begin that again.
You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
Please state your name slowly, it's fine.
Kevin Kleins, CLYNES, 46 Burnett Road, Warwick, Rhode Island.
Go ahead again, Mr. Collins. That's okay. That was our error.
So I bought a piece of land on East Prospect and meeting with the building officials and everything to try and subdivide the lot into two. I followed all the guidelines. Kevin Cleary wanted to make sure that the new lot on the left would have an OWTS system. I've gone through the cost and expense for all of that to be designed. I made sure, I said, whatever hurdles, please, I can't keep affording to go back to engineering. So Kevin Cleary said, yes, this is what I'm expecting because we don't want to overload the system. So I've gone through extensive stuff, paying for engineers to make sure the OWTS, it would perk for the additional lot. And the new court, I mean, the new development that you guys just approved not too long ago, Lacey Court has a sewer easement that's through their portion of the lot that goes on to mine. And there's a power line easement that comes through there. So it's more than ready to be developed. We also met with the fire department. We originally came up with a scope to build a 40-foot cul-de-sac to have everybody to be able to turn around at the top on my property. During the last meeting, they wanted to expand it to 45 feet to make it accessible for ladder one for existing thing. We immediately the next day came up with new drawings, designed it for that. So if you come to the end of 29 East Prospect now, at the end of my street, there's a piece of ledge and it's just the end of the street. There is no access for emergency vehicles in the situation there is now. So I've upgraded and I'm improving the whole cul-de-sac. At the end of my street, where the trash trucks have been coming up to the property as well, they come up bottleneck, they're turning around in the dirt and they are having difficult access turning around. And I haven't seen it myself, but I'm sure the bus schedule would probably be under the same restraints. So any kind of emergency vehicle that would come up to the end of that property, at the existing road is now bottleneck in. I am improving that for everybody's betterment. So with that, I followed every standard, every recommendation from the fire department. They're happy with the existing location of the fire hydrant that's there. Everything is to code. I've met with Mike Phillips numerous times to make sure anything that you would ask for. I wasn't able to make the last meeting here. If there was a question on the size of the easement, which is on the drawing, it showed 20 feet. When I met with Mike the last time in his office, when he came back last week or the week before, he found a document that was grandfathered in that already shows that that easement is 25 feet. So
You weren't here the last time, and you had a representative here, and since there was concern by some of the public, yeah, as well as questions that the board had regarding the easement itself. And whether or not legally the easement for the use in which you would like to use it is essentially the same that the use was prior to your project. And there was a discussion perhaps that your representatives may have, or you contact some of the abutting owners. Can you bring us up to date where that is?
I have 3 out of the 4 abutters. I have all the documents notarized for all of the 3 abutters for everybody that's and the only one that didn't sign was Raymond Church at the bottom of the street. I've tried to contact him. I tried going by his house. I tried to contact him by text message. He sent me over to his email, which I responded back to, sent him over what we're intending to do. And he said he declined to sign it at the time. I tried to respond back to him to ask why, to try to meet with him, show him the improvements that we're doing. Because with his location of his house, this is directly in front of him. So I thought I could at least explain how this would be helpful to everybody.
The nature of the documents you got from the other 3, what type of document are they?
They're releases that they would all allow it, and they're all on board with the development that's there. Right, I already brought these to Mike Phillips. He has a copy. I have the originals with me.
Questions of board members?
There we go. Alex, let's see, could we just briefly address each memorandum of agreement, letter of consent? You have one here.
Tara, can
Yes. I have a copy in front of me that has his signature, but
he was in Florida at the time, so we contacted him. I have all his contact information. If he'd be happy to contact him, I have everything from him, but he was not available. He's in Florida.
No notary,
Excuse me?
no notary either.
On this copy.
no. There's a gentleman from the bar right here. There's a gentleman from the bar right here. I'm going to ask them, is this a legal is this a kosher legal document?
Well, it depends. I mean, it certainly, it could be open to interpretation, notarization, if ultimately the issue, if that individual contested in the future that he signed it.
No. Nobody's witnessed his signature. And it's not, countersigned by Kevin, Hines.
The bigger issue is there's one that has not signed
And
that we're going to,
I don't know if they're here.
they're here.
Okay.
And
Okay.
let's assume for argument's sake, there's 3 out of 4 that are properly executed, documented. Without the 4th, that's going to present an issue for us.
Then there's Tristan Development that's signed and notarized and stamped. Then we come to Ray and Lisa Church. There's Mr. Klein's signature, there's a notary signature, and then there's two lines.
We were not signed. I only signed it that I did it, that I met with them. I mean, I tried to, contact them, but that's not a signature for them.
That's because, I mean, I've been told past it, somebody could put an X. And as long as it's witnessed,
their mark.
yeah. So, again, I'm questioning, this document, and apparently he has a new one from the gentleman in Florida that we haven't seen. And,
But I did not say that Raymond Church signed that. I did say I signed it and I tried to contact them. I was just.
okay, well,
authorized.
that's why I'm asking, because like I said, the chairman said that, yeah, they can put a mark, and I've seen signatures that look like no kind of writing on this planet. So
Well, that's usually the reason why a notary confirms that
that's right.
mark, the signature, or
Thank you,
whatever.
Mr. Chairman. That's all I have right now. Thanks.
Other questions of board members? Of Mr. Klein's?
Mr. Chairman, I put the issue, last month was the fact that on this drawing, it says that the easement is, the existing easement is 20 feet. And, it was intended to go to 25 feet, but under his testimony, he mentioned that Michael Phillips has a document that says 25 feet.
Mike found that. I did not find that.
So I guess my question is do we need Mr. Church signature? If
Well,
the intent is that
if I, yeah, well,
it is, and this document says 25, I see that a drawing that was done by a certified surveyor has, existing 20 feet, so I'm not sure why that's.
I'm not sure that was pulled off, but I share an office with, Bob St. Angelo from Canavan Associates. So the newer drawings have it documented as 25 now.
you have new drawings, were they given to Mr. Phillips?
Everything was sent by email directly from Canavan Associates.
One of the concerns that the solicitor brought up was the fact that the easement was initially for one parcel, and whether putting a second parcel then changes the nature and quality of the easement. And we don't know the answer to that, right?
So that's why on my own expense, I tried to build the cul-de-sac to make sure that's not just a benefit to myself and one other house that's on the development, but the whole neighborhood will now be coming up to our front door to be able to be, especially for the fire department was adamant on the size of what they were looking for. They knew the benefit of having that in an emergency. So I don't know why that would be something everybody wouldn't want. It doesn't make any sense, but.
So in the perfect world, you would have the abutters all agree and consent like some of them did. If they have not, that raises not so much questions with the project itself, but other legal issues that we're concerned about that needs to be resolved before the project. Just giving you some thoughts in terms of at least how I was looking at the interplay between the parties, the testimony that we heard last time. Not to say that I don't necessarily have a problem with your proposed project. It's this other issue that I think needs to be resolved one way or another. Any other questions of the board members?
Does the easement, whose property does easement cross to get to your development?
Tristan Development, Diamond, and Raymond Church.
No churches.
So Raymond Church first, it's the first lot that's there.
Yep.
It's an undevelopable lot. It slopes. The other parcels that come through are from the opposite side of the road, and they're triangular pieces under a slope. None of it's buildable. So nobody can develop off of this. And then it was concern about building beyond all that. Just, we've deeded over part of my property to the town in this project too. So I mean, there's nothing else that can get built. This is it.
Number Yoko, the easement also passes through town property.
Okay,
Have a plan in front of you.
Yeah.
Crosses the church. Then, Delanio, I think. Then, Greenwood's property.
Yeah.
Then it goes to a section of the town. That's gonna be-
Has the town taken a position? With-
I have not discussed this with. Well,
Does that need to be done? Sure, and given that the easement runs through town property, will consent also be needed from the town, given the same concerns that were brought up last time regarding the nature and quality of the easement and whether this is going beyond the scope of the original easement?
So I believe that this board can make that determination.
Which determine whether the town needs to approve?
You have that as part of approving this development. You would be approving that expansion piece. You have that. So, as part of the development.
Of the easement that runs through private property? For the town, we have the book.
This board said that we believe this project should go forward. And it expands that easement on the town section. Your decision is binding for the town. For that section. of the easement.
Is there precedent on that? Okay,
But my original legal opinion is that this is an expansion of an easement that this board would have to have addressed by the owners of all the properties with an agreed upon document of what the expansion is of the store.
and right now it appears that assuming the gentleman from Florida, that we're gonna get an appropriate notarized document, there's 3 out of 4. Apparently, the 4th is unwilling. We'll hear from Mr. Church if he so chooses when we open this up for public argument or public comment.
That has, my legal opinion has to
Be resolved prior to this board.
So my only question is, it's grandfathered in as 25 feet. It's not,
That's not the issue. The issue is not the width. The issue that the solicitor has raised is that easement was initially intended way back for one parcel.
Okay.
By creating 2 parcels, you're changing the nature and quality of that easement in terms of potential traffic flow, use, etc. And there's a concern potentially for legal action that by doing the subdivision, it changes the nature quality of the easement. And the town doesn't want to sign off on a project until all abutting owners have signed off or agreed, or some other type of action takes place to resolve that issue. So it's not so much the 2025, it's more, has the quality of the original easement changed given the subdivision? That's how I understand the issues last time we were here. Okay, so with that, should we
Yeah.
open it up for go ahead, Joe, you got a question?
Yeah, I know Mr. Klein provided a copy of the handwritten copy of the easement that it was in the land records. Can we take a look at that
Yeah,
after
so-
Richard, after you're done, Richard?
I think we had that with us last, I remember seeing it.
And in terms of the general scope of it, part of the reading that you'll see in the earlier, with the bottom of the first paragraph, it says full liberty and at all times, for all purposes, with or without horses, carts, carriages, or wagons, pass and repass, and to drive cattle and other animals over and upon the said way. That's pretty much the scope of what the easement is for in that first paragraph.
But over the last 60, 70 years, I'm sure it's been used by motor vehicles.
Right. To have whoever lived in that house have access to that house.
I don't think anybody came here on a horse, did they? Too hot for that?
Yes.
Go ahead.
Yeah, I'm just wondering about the presentation of the idea that because any of the property you're going through isn't buildable, that makes it less, or less rights for the property owner or something. It sounds like decreasing the value of the abutter's opinion because it's not a buildable lot. I mean, it's still their property. So it's important to hear from them on that. So,
I did my best.
thank you.
And I'm not changing what's there. What's there is already
Right.
existing. It's not like I all of a sudden I'm asking for an easement to a part of land that's landlocked. This is a parcel that's already existing. People have already lived there before.
Yep.
So it's not a new easement and I'm not expanding the easement. I'm just trying to build a second house. With that, expanding a cul-de-sac for safety.
Thank you.
Open it up for public hearing? Okay, it's, you could sit down, Mr. Kleins, we're gonna open it up for public hearing and then you have the opportunity to speak thereafter. It's now 6:21. We're gonna open the matter for public hearing. Whoever would like to speak, please come forward, state your name and address, please. You both came last time, so it's fine,
Go first.
please.
Sir, please swear the testimony you're about to give is the truth, nothing but the truth, and nothing but the truth.
Yes, so help me God.
Your name is spelled last name.
Raymond Church, last name CHURCH,
Your death. Address.
address 16 East Prospect Street, Smithfield, Rhode Island. We also own 20 East Prospect Street.
Amen. Please swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do. And my name is Lisa Church, CHURCH, and I also live at 16 East Prospect Street in Smithfield.
Who's gonna go first?
Oh, go ahead.
Mr. Chairman, members of the committee, thank you. Just a couple of things. As far as the property going, the road, the statement was made that my road goes, that's not a road. The road stops and it's a driveway easement. And as far as trash barrel pickup or snow plowing, those services are not supposed to go over that road. At times, some of the public service companies did, especially when there was a change. I told you I've lived there since 1969. That property was my grandfather's, then my father's, and now ours. And so originally the owners would bring their garbage down and put it next to ours. At one point, there was a change in trash disposal pickup. And somebody didn't know when they drove the truck up the road when the prior owner lived there and hit his wall. And he wanted them to fix his wall and they looked at it and said, we're not even supposed to be up there. And so once again, he had to bring his trash down. I have photos with me if you want to see them of, depending on the snowplow company that would plow, some of them would stop right at the end of the legal road, would not plow the easement. As far as a bus, somebody needed to get special permission for the bus to go up and turn around. The bus driver said, I'm not supposed to travel over there. And yes, it was originally for, I guess, cattle or whatever. For the past 20 years, no one has lived up there. I've got the date of loss was October 1st, 2004. So there's been no residents up there for 20 years. It's been vacant land. So it's just to pass through. Interestingly, it is on the town document. I afterwards, I searched some things that I had at home from my father. It is, I don't dispute that there is an easement documented on the town map. My father had a lawyer look into it, and they consulted with a land surveyor, registered land surveyor, and a Rhode Island lawyer that says, you know, the easement is on the town map. There's no legal document on record establishing such an easement. Now, this is a private letter from the lawyer to my father, but when I read my legal description of 20 East Prospect Street, it doesn't reference the easement. I realize there's documents floating around maybe for 29 East Prospect Street, but I've got, when my mother transferred the property to me, I've got a legal description. I don't know if that's where I would see the easement, but I'm not here to dispute what is already there, but I'm definitely here to say no more expansion of what it is. My father came before this committee. I've got the documents some years ago to seek to get a building permit for that property. So to say it's not a buildable lot, I would dispute that. You know, certainly there's problems with the lot, but I don't think anybody else has the right to say it doesn't matter. So there's a lot of issues I have with some of the statements that were made. And again, if you want to see the pictures of the snowplow, my kids were outside and took pictures, and it stopped at the end of what's legally East Prospect Street, did not cross the easement. And you can see the tracks where it then went back down. So I don't know if I have anything else, but go ahead.
I don't know if there's any other questions, but.
Mrs. Church, is one of your issues the fact that there's two proposed dwellings as opposed to one?
Absolutely. Yes.
If there was one dwelling, are you in the position to object to?
We don't object to what was originally there. Not at all. We're not here to contest what was originally there. What was there was there. And so, you know, I think that there's questions legally with the easement. I'm not here to contest those, but the expansion of the easement, I strongly object to.
Well, that's what I wanted to get a
I'm
little
sorry.
better handle of, because you intimated perhaps there wasn't a proper easement or not. but
It's not clear that there is. I'm not here to stop somebody from building a home on the property, but I mean, my intention was not to come here to say nothing should be built, but I think that there's a question there with the legality of the easement at all. But certainly expanding it is definitely not something. We live in a very pleasant, my neighbors are here, my family's here. It's a very pleasant area. I don't want to be arguing with people over land use. So I don't agree to an expansion of what has been there in the past.
Do you mind passing some of the photographs?
Sure.
Mr. Chairman.
Go ahead, Jude.
She's busy.
The first series are up the street. The last one shows you the other way down the street, so you can see where it was plowed. May I approach?
Yes.
Chairman, you have those marked as the butters.
Are we keeping these, or do you have any objection to that?
No.
Okay, we're going to mark the collectively as a butters A.
Yes, you just identify how many.
3, 4, 5, there's 9 pictures.
81, 2, whatever it is.
You pass those down. Did we get marking the exhibits A1 through 9?
Mr. Chairman, may I ask?
Yes, of course.
Mr. and Mrs. Church, is there any reference in your deed to the easement that is part of this agreement?
What I have in front of me is the legal description. Would the easement be in the legal description? It's, if it, what I've got is my title, my title, insurance with the legal description attached. I pulled that out. I don't know that I,
Can we see a copy of that?
I think we'll have to mark it if we do. I don't know if she's got a copy. I don't want,
Michael can make a copy of the books.
okay.
I'm also going to enter the town's deed, which has a reference to the easement as well.
You're gonna make a copy?
Yes.
Thank you.
And Mr. Chair, while we're waiting, for record purposes, that the client submitted a couple of the signature documents. Did everybody have those documents in your package already?
In the package, although Mr. Kleins has some that are slightly different.
Which he did not present.
So let's make that exhibit 1 for the app.
Mr. Klein's document, is it an original or a copy, Mr.? If we're gonna make the copies or the originals? I mean, I think we should make copies so he has his originals.
Where do you have, right, what did he?
We don't have anything yet.
Okay.
Which documents, Mr. Kleins, would you like? Okay. All right, and we'll mark them as an exhibit. And we'll see if we can have those copied. David, you know where Mr. Phillips went? Because we're going to need copies of these
He's
three.
went to the copy machine.
Yes. Resolve this, resolve it. Resolve it.
Yeah. This is the notary statement. I'm waiting.
Could, uh, could I ask the chairman, do we recall, the, date of the approval, that this application was certified complete?
I don't have that date, Mr. Phillips might. Mr. Phillips, we're gonna need some more copies for, if that's okay with.
This is not the TV, this is just a reference to.
Okay. Mr. Kleins, could you give Mr. Phillips those documents?
Yeah, those, you should have those in your packet.
Yeah, but the solicitor wants, they're different slightly and he'd like to mark those. Yeah, so that's why we need copies.
Okay.
This is the towns. Oh, that's the churches.
Number one, certified complete. May 22nd.
Yeah, Michael? Mike,
95-day decision period expired on August 25th.
and what's the options?
Further continuance and if the applicant would agree to an extension of the decision date, there is further information received. Or make a decision on the application.
Because there's issues involving private parties that need to be resolved.
Based on my, correct,
Yes,
I think there should be opportunity for the private parties to speak. Decide if there's something they can agree upon. Before court action makes that decision for them in 4 years.
well, the-
So it's a legal matter to decide to go with the easement.
Okay.
It's done privately, or one party takes an appeal from your decision and it's done as that one.
Mr. Chairman, has the solicitor looked at that, the exhibit presented by the churches?
I don't believe so.
Yes, I see.
Okay.
The deed reference?
Oh, the deed, I think you meant the sign.
Well,
No.
No, I have not seen.
well, let me mark, this as, Church B, which is the legal description of the property, and then I'll have the solicitor take a look at it.
Yep.
And we're gonna, while we're doing housekeeping, we're going to mark as Klein's 1, which is a memorandum of agreement and letter of consent that's executed by Mr. Klein's with lines for the churches, but Mr. Klein's has indicated that that was not intended for the church's signature. It's his signature is notarized, meaning Mr. Klein's. Klein's Exhibit 2 is a memorandum of agreement and letter of consent signed by Tristan Development LLC and Mr. Klein's with the notarized signature.
You almost two parcels of it, one other part is.
Okay. We have another memorandum of agreement we're going to mark as Klein's 3, which is another memorandum of agreement entered into between Tristan Development LLC and Mr. Klein's. This is for another parcel that has been notarized and signed. Klein's 4 is a memorandum of agreement and letter of consent. Diomede LLC, it's executed by Mr. Klein's. There is a slash for the signature of Diomede. Is that and to be its signature or? Okay. Okay.
I put his contact information.
Okay. So this is not signed and not notarized, although we do have in the package. Do we have a copy of that, Michael? That you were talking about the one from Florida?
I have one.
You marked it up.
Yeah.
Does anybody else have another copy?
Yeah.
I don't want to mark, I don't want to have your copy.
Yeah.
This might as well enter that to the record as well.
There you go.
This is, yep. We'll mark as Klein's 5, a memorandum of agreement. It's the same one as Klein's 4, however, this is signed by a representative of Diomede LLC, but is not notarized, not signed by Mr. Klein's. Does that take care of all paperwork and documents of the exhibits to date?
Yes.
Any for
Mr. Ursula,
At 1 through 4,
5?
with 5. Oh,
Well-
the one that's,
Mr. Chairman,
Go ahead.
when the solicitor is done writing. Mr. Ursullo, did you see the document presented by the churches?
I have,
Is there is no reference in that document to an easement.
there is not, but this is part of a title search. And I don't know if it's the complete description of the property, and I don't know if this title search included other items in the title search that would have included the easement. Because when you get the original title search, there's a whole bunch of things that might be on there.
That's the reason why I'm asking about that particular portion of the deed.
Trying to also see if I can pull up one of the deeds online right now.
I'm,
Copy or the end of this is the that's that reference.
is this, do we mark this?
Yeah.
Okay, we're gonna mark as town exhibit 1. The documentation regarding the town ownership of the land with reference to the easement. The parties, when I say the parties, Mr. Klein and the church may have overheard some of the comments made by the solicitor earlier regarding what potentially could happen. Is there any interest of speaking with Mr. Kleins to see if there can be some arrangement that it is equally agreeable to both sides? Is it?
So I will answer that and my husband can answer that, but to correct a few things, the three out of 4 or 2 out of 3 entities signed off. Realize that Tristan Development and Diamati don't live there. Tristan Development is developing and selling. Diamati is an Airbnb where people come and go weekly. We had fireworks on 4th of July. We've got things thrown over the side of the railings, all kinds of things. Those entities that signed off don't live in our community. I've lived there, as I said, for 55 years. And as far as, there was something else I was going to bring up, approaching us, I worked from home on July 2nd and I had a meeting online. And when at 3:05, there was a loud bang at my front door and a ringing of the doorbell. And it was the first time that this gentleman approached our house while I was working from home. I could not answer the door. I didn't even know he was at the front door. I went to peek out another window and he was at my basement door and he was looking up. And then I had to get back on my meeting. And my office is in the back of the house where my dogs were tethered and they went wild. Somebody was approaching the back of my home where they had full view of my house. That was Tuesday, July 2nd at 3:05. At 8 a.m. the next morning, the gentleman returned. My husband's at work. Both times he wasn't home. This time just the front door. It left one a little unsettled. So, and I'm sorry, but the document that was placed in a file that has a notary without my signature leaves one rather uneasy about approaching these things, I would say, from my perspective.
The point being made is, the city solicitor, the
Yeah.
solicitor made comments and very astute in terms of where this potentially is going to go, unrelated to any particular jurisdiction that this board has. It's really issues between private landowners. And there's no harm in potentially talking, but if you're not interested, you're not interested. But it's helpful for the board to know if there's a willingness to talk or not, because that might help us.
We were, when we left here after the last meeting, what was that man's name? Yeah, Pat. Well, he said his name was Pat. He didn't tell us his last name, didn't tell us what he did. He took my husband's cell phone number and said, we'll be in touch. We waited, nothing. We had to come here and get from the town the contact information, and then we got a phone call. So we told Pat we would respond, but we never received any contact until July 3rd.
Is there an interest?
That's up to you.
And not forcing you one way or another. It's helpful to us in terms of what we're doing, whether we know whether that aspect of the camp.
As the owner and the resident there, I'm not interested in a second law up on top of a hill. I'm not, but you can
Okay.
say for yourself what you think.
Mr. Church, anything else?
No, I thank the board for catching the unsigned, notary paper, which raises a concern, I know, with my wife, but certainly me, and we look down the road in 50 years, you know, if somebody sees that, I don't know how that gets
Mr. Chairman,
reported, whether or not those are our signatures or not, but I appreciate board member, Mr. Nolan. bringing that up.
Well,
Mr. Chairman, has this gentleman seen that document that he's referring to? Have you seen that document, Mr. Church?
Briefly, so the day that July 3rd day where we didn't know who was at our house. We came to the town, we also went. No, I'm sorry. So July 3rd, when we didn't know who the gentleman was that was at our house, we had an assumption. We did come to the town, and sat down and tried to ask and inquire.
You've seen that?
He did show us a few signed or unsigned. So that was the only time.
Mr. Chairman, for the record, I believe Mr. Klein during his testimony stated that he did not have the signatures of the church
Or anybody.
before that document was entered into this record. So, I mean, there is no, he did indicate that there was a notary for his signature, but not the church's, and that was not purported to be the church's signature on that document. That's the first thing. The second thing is, has this agreement, memorandum of agreement been put into the record
It has not.
as an exhibit?
It didn't last time, at the last meeting? Because we, remember Charlie brought that up, Charlie,
I think it was now.
I think it was.
But out of an abundance of caution, to the extent it has not, we will mark that as Klein's exhibit
That was from
I think that should just
No.
be, town.
or town exhibit number 2.
Mr.
Wasn't one the deed?
Town, okay. Yes.
Thank you.
Okay. Anything else, Mr. Church? Thank you. We're gonna have Mr. Kleins have the opportunity to respond.
Legal description.
Before Mr. Klein testifies again or presents anything, okay, I'd like to make reference in this particular agreement, memorandum of agreement, to the next to the last paragraph. It says the following: and in the event of any dispute arising as to the use, location, or any matter arising out of said right of way, the parties hereby agree to leave said dispute to 3 disinterested persons, one to be chosen by the said, I can't read that name. What is it? Oh,
It looks like Leon.
Leon Son,
Leon
Leon,
Ensign,
okay.
and another to be chosen by
Chosen
said
by
Hartley. Those are the original parties to the,
And the third to be selected by the 2 already chosen. Has anybody,
But just, could you do your best to try to spell that name for the record?
yeah, Leolllinson.
Member Fratelli, your question?
My question is, has anybody referenced that particular provision of this agreement and sought to put a panel together to resolve this dispute?
I only saw that.
Excuse me?
I only saw that last week from the town when I met with Mike Phillips, that he showed me the 25-foot easement part.
That would not be the purview of the town.
No, it's the purview of the
No,
audience.
this- This is all private party issues that
But
are,
in my opinion, exactly.
that's,
Can I just clarify everything?
yes, you wanted to comment on,
2 seconds. I made it clear the second I got here, I did not have their signatures. The second I got here, before you guys reviewed anything, I would never falsify documents. I own a large company in this town and I pay all my taxes. I have no problems. I built my building from the ground up with your building department, everything that's here. I don't have an issue at all. So I would never falsify a document. Secondly, I'd like to state, when this board meeting met before, I was not able to attend. I had somebody come in my best interest. The following day, Mr. Phillips was out of the office, and then the following week, he was away on vacation. I immediately got drawings redone to everything that I had understood from what your concerns was, the easement, the enlarging the cul-de-sac to 45 feet. That takes time. Then Mr. Phillips was away on vacation for the following week. I could not go address anything with the neighbors of what was a concern or what we were trying to fix. I didn't know. Right? I needed to clarify before I go to speak with somebody. So their misinterpretation of what happened, like I had delayed anything, that's the furthest thing from the truth. I was getting all of my ducks in a row and making sure when I went to speak to somebody, I knew exactly what I was going to be talking about. I would also like to agree with the churches. She has pictures at the end of the street where the snow comes to the end. I'm trying to help alleviate that. I would hope that I can explain that, where if the snow comes to the end and she's saying that the buses are coming up and hitting the wall, obviously they do use the easement. Obviously, the trash trucks do use the easement. It's not being used. So I'm trying to build a cul-de-sac to make it safe. I would do anything to try and settle this with everybody to make this better, but there's no way I falsified a document at all. Oh, wait, one more thing.
yeah, go ahead.
When I did go to their house, I didn't have a phone number. And then if their house is a multi-level house like this, there's a lower garage with a door, there's an upper garage, and they had dogs in the back. I didn't know which door to go knocking on. It's, believe it or not, you guys are my age. You go to somebody's house and you knock, like that's, I didn't know. So the dogs being in the backyard, I rang the bell, the bells never get touched anymore. So the doorbells don't ring. So I was knocking on the door. It was a normal time of the day that I would think that anybody can understand, 3 p.m. So when I asked one of the neighbors, I said, hey, do you know if they live here and or what they drive so I could recognize it? And the next day, I think it was a black Suburban. So I went in the morning, maybe catch them before work. I didn't go extremely insane hours that I would think, but I was trying to go meet with somebody face to face, which nobody does anymore. For that, that's what I did. But the duration of time was me waiting to find out exactly what you guys wanted for me to present to somebody else. I couldn't just go there and shoot from the hip.
Any other questions of board members of Mr. Klein? Did I officially close the public hearing?
No. We still have over potential people to hear from.
Okay. Is there any other members of the public who wish to be heard?
I know.
Not hearing anyone responding, we will close the public hearing at 6:53. Do we have,
Is there any way with clarification of those concerns they had with me going to the house? Would they like to speak? Because they said they were open to that before. I'm trying.
it sounds like they are not from their comment. Mr. Rotella brought an issue up regarding the actual easement and what the easement may say in terms of resolving disputes like this. But, again, this is getting into issues that are not before the purview of the board, but affects ultimately what we do.
Would you like to speak quickly about this or no?
Oh, sorry. Would you like to? Okay, so there's been a question of Mr. Klein's whether the churches would be willing to speak regarding the issues. Did I understand you, Mrs. Church, indicating that you are willing to speak? Okay. Okay, so why don't we suspend right now to allow the parties to speak? When you're done
Please.
speaking, we'll have you come back and we'll
Please.
continue with the matter. Thank you. Should we go with the next matter? While they're speaking?
Yes.
New business DRG Realty LLC ID 2403. Put pre-application for review. I know, but still they still have the confidence. Sorry about that.
That's fine.
Could you state your name and?
Sure. My name's Doug McLean. I'm here on behalf of DRG Realty. Dominic Greco could not be here. He's out of state at the moment. Sam Hemingway is here as engineer on the project. Is it helpful at all to try to put the site plan on the screen, or do you feel comfortable with the plans you have in front of you?
No, so if you have it, it'd be helpful.
Okay, we'll do our best there. While they're putting together the tech, I can give you a brief overview of what the proposal is, and then when the site plan's on the screen, we could certainly take questions. We can discuss any of the specific details. In large scale, what the applicant is looking to do at the site is to redevelop the site. There's an existing office structure there. They're looking to demo the existing office and proposing a 45-seat restaurant with cigar lounge. This use of a restaurant with cigar lounge is allowed by right in that zone. It is a commercial zone. They're looking to use a very similar footprint. The demolition would occur and the new building will be built in the same footprint with an additional 28 by 28 expansion to the rear to increase the size of the overall building. So the project is a minor land development because of the fact that there's new commercial development, and there is associated dimensional relief for this proposal. So this is going to be classified as unified development review, in which the planning board will be considering a minor land development as one decision, and then the dimensional relief as a second component of this project. The dimensional relief is one is a side setback. So again, the structure exists now. They're looking to rebuild the structure in the same footprint. The structure is currently 34.4 feet from the side. The requirement is 40. So we're seeking relief to essentially demo and build in that same area. The setback that exists today would be the same setback relief that would exist after the new building is built. There's a second count of dimensional relief. The second count of dimensional relief is regarding commercial development. Looks like the site plan's coming up on the screen now.
Can you show us where the relief is on the document?
Sure. Yes, please. Sam, if you don't mind first pointing out the side setback relief. You're just a touch lower than that. I got it, Mike. Thanks.
From the butter to the left, or to the north. This would be about the east. Butter to the south.
So the 34 feet where it should be 40 is essentially that right there, that distance. Again, in gray, you see the 28 by 28 expansion. And then this is the other area of relief. There is a minimum distance between the commercial structure to a residential zone. So we're seeking relief there. That's 16 feet. And 16 feet that we're proposing, yes. And no, they will, the standard in code is that a commercial structure should not be within 100 feet of a residential zone. In this circumstance, their existing structure is considered non-conforming. There's about 35 feet existing. They're expanding to the rear. That would become 16 feet. And I think that's worth focusing on for this particular application. I mean, that essentially out of the relief we're seeking, I think the side setback relief is not changing. You can see the existing structure is in white. The new addition would be in gray. And we are moving closer to that rear property line. And that is a residentially zoned property. And you see the existing residential structure here. That's where there's a home. I'd note that the applicant, Dominic Greco, has been in direct touch with that existing property owner here. They've begun to communicate about the proposal and to mitigate any potential issues. And we do not anticipate any issues with that abutter at this point in time. We are showing the evergreen screen, the new plantings that are being proposed. At this point in time, there's communication occurring. They're being made aware of it. We're taking comments into account, and we do not anticipate issues at this point in time. Just to summarize, it is a pre-application, so really we're just seeking your feedback. The next stage of this application would be a preliminary plan submission in which there'd be additional engineering, but we know the key points of relief that need to be sought. We're seeking your feedback on that. You know, I think that this is a nice improvement to the property. The existing building that is there now is old, it's tired. There are structural issues. There's some sagging that's occurring. That's why the decision was made to demo the building instead of try to work with it. You have some architectural renderings of what the new structure would look like. I think that, you know, there's a nice improvement being proposed here. The use is allowed by right. But with that being said, we're open to any comments, questions, or feedback that the board may have.
Mr. Chairman, I don't think we have renderings of the exist.
Yeah.
I don't think we have renderings.
Mr. Chairman,
Go ahead, Joe.
can you ask if there is a rendering of the old building that they're attempting to knock down?
It's an old, it looks like a residential structure. That's an old house. I don't know if we have a render. Oh,
I think it's a white.
yeah, he does.
I think it's like a white bungalow.
There you go. We did have a picture of the existing, in that structure, the main.
The commercial structure?
That's is being used for commercial purposes now as an office, and the structure in the rear, this accessory has already been demolished. So that is gone, but this structure is there today.
And the abutting landowner is where we talked about the 16 feet, where is that? Yeah.
That's to the rear of this. So yeah, you'd be looking at this corner over here. To the rear or to the essentially the north east. Are you trying to do side by side, Sam?
So
It's pretty good.
if I may, Mr. Chairman, why not, there's an awful lot of relief number wise being asked, so why not just reconfigure the new structure to move it on the lot so as to request less relief?
It's a good question. There was some thought put into, first, the expansion of the building, I think, is a component of seeking a certain square footage to make the restaurant use happen. The other options, become tricky because one, if we move farther to, if you're looking at it on the street and you're looking at a site plan, if we move it farther to the right, we're getting farther into the side setback. If we move it closer to the street, that can create an issue that we're moving this resident or this commercial use right upon the street. We're already close to our front setback, and then moving it any farther to the left is really not, assisting with getting it farther away from that residential property to the rear. And I think the applicant is looking to take advantage of the existing foundation. I think there's a reason why they're working within the same general area of footprint. They're gonna demo the structure, but utilize components of the existing foundation.
Why not configure it as an L?
That's a good question. I think that they're also trying to navigate, ensuring that they've got the adequate parking. They didn't want to seek parking relief for this use. So in order to do it as an L, let's just say you did it as an L, where this building was kind of coming off here, we're probably starting to choke into our ability to do a parking design in and around there.
In here. And then have parking back here and over here. With a drive around here.
I know that there's an OWTS that would be considered here, and that area in the back is essentially dedicated to, it would be an OWTS system. I think you raise a good point. I think that the configuration now, when you look at it, the L may constrict the ability to do vehicle traffic in and around. So I think there's one limitation there. But I think part of it is that we understand that that distance is short. There's a residential structure there. If you do it as an L, from the view shed of the residential structure, it might not be an improvement because, essentially they're looking this way. There's a distance here, but doing it as the L, this becomes a broader side of the building to look at. I think this is the key abutter that we're trying to work with and communicate with so that they understand it. And then we're trying to design this in a way that meets some of the issues that they may have. So I think there's an active conversation happening there. That's one component that we could bring up, as if shifting the building is seen to them as helpful in any way, shape. That might introduce traffic movements that will be coming past and around the building. They may actually prefer to have the building actually located where it is and keeping traffic where it is. I should note right about here on the subject property, there's a substantial change in grade, right where you see the edge of the parking. The subject property is lower than the abutting property to the rear. There's a wall here that must be about 4 to 5 feet in height. So a lot of these plantings are occurring on top of that wall, and the subject property headlights and such would actually be beneath a 4 to 5 foot wall that exists right in this location, and it turns the corner here as well. There's a significant grade change right around these points.
Can I ask a question?
Please.
Where is the driveway gonna go around the building?
I'm sorry,
The driveway, is it gonna go around the building?
not currently, no.
Where are the dumpsters gonna be located?
That's a good question. I think that's a component that we would look at. I think there's opportunities to potentially do some dumpsters here, and that's something that we could come back with at the next preliminary plan application. The next time you would see this, we would have dumpsters located on the plan.
And what about snow removal? Where are you gonna dump it?
I think we have opportunities to do snow storage at various points of the parking area. There's also potentially ability to do some snow storage in the areas in the front here. Sam, if you have any other ideas on that at this point. I think those are good questions, and those are things, I mean, as a pre-app, this is conceptual, but those are things that you would see on the plan as part of a future submission. Again, I think our conversations with many of the improvements are ensuring that there's communication with the abutter, trying to ensure no issues. So as we make those decisions, I think those things would be discussed.
Any other questions? Okay. Michael?
The paper street, Grant Avenue,
Yes.
is that on anybody's radar scope to be, used, activated?
Not,
That you know of?
not as part of this proposal. They're not seeking any rear access as part of this proposal. I think my understanding is that this is largely a parking area now. It's a parking area that supports the abutting commercial use. So you can see the abutting commercial building is right up against the setback here. This is the abutting commercial building. And I know that this entire rear area is already dedicated to parking. I can't really speak to this applicant and then this immediate proposal. There's no intent to try to gain access or to change the what's happening with that paper road. I think they're looking for the rear of this lot is largely going to have an OWTS system. I believe that there may be parking that's utilizing some of this area. They're not looking to activate any exits in the rear at this time.
Thank you.
Any further presentation?
That's it from us.
Any comments of the board members? I think critical is getting the abutting landowner to be on an agreement.
Yep.
Given the request for the setback. Do we take a vote on this or?
No.
Okay. Is that,
Well, I just want to kind of get clarified from my own notes mostly. So the issue that we've been talking about is the separation, and whether or not there might be an opportunity to relocate the building and the like. If the abutter does not object, is that dimension one that's so critical to this board that alternatives should be looked at? Again, I was directly involved with the discussions with Mr. Greco about moving the building on this plan to the east and to the south. There are both physical constraints, engineering constraints, and then the foundation that were all noted. So that decision was one that was made through initial investigation. Not to say that the book is closed, simply that, you know, this is the configuration that we felt was the most favorable to him, to this project. If the board has a significant concern, even if the abutter, issues are resolved, then we kind of like to know that so that we have a path. I think the big thing that is not, hopefully it's all made clear, is that the next step is to get permits that are pretty specific to this use. And that this use is how, as it's presented, is kind of part and parcel. So I think we were looking for initial input so that he doesn't approach the state about the change of use and design a septic system with a certain use. If the board has a significant concern, obviously any input we get is helpful.
it doesn't sound like that. It sounds like there was inquiry whether other potentials were looked at, and if not, why not? And it doesn't sound like anyone has a major issue if the abutting landowner has no issue. So
Thank you. Yeah, and I think we agree that the key issue here is the abutter to the rear. The expansion is moving to the rear. The use is changing from an office to a restaurant, so you would assume the nearest residential abutters would be of interest to that type of change. That's why there's been open communication with that abutter. And I know that that's still ongoing. Mr. Greco has been out of town for the last week, but he anticipates also sharing the feedback from the board and also being very open about sharing the plan with that abutter and gaining their feedback, addressing comments, addressing any issues as they come up. And that's something we can give you even further clarity on when we come back. And I should note, just for the record, the use that they're seeking, it's a restaurant with a cigar lounge. They have already achieved a liquor license through the town council. So there are certain components that they need from other decision makers. They've achieved some of them, but clearly there's still a land use decision that's in front of your board.
perhaps the next time the snow removal plan and
Yep.
dumpster plan that was raised by one of the board members will be helpful.
Yep.
Thank you.
Good comments. Thank you very much.
Thank you. We're gonna go back to, old business Kleins. 29 East Prospect. Mr. Kleins, could you come forward? You had an opportunity to, speak to the churches. There was any headway made?
No.
Okay.
Nope.
No. So our options, are to approve, deny, continue, or conditionally approve. So we have the option to conditionally approve based upon an ultimate resolution of the underlying easement.
Are we still dealing with the legal use of the easement in terms of?
Well,
being-
we can't
one lot.
decide that issue.
I know, but that's affects our decision
Well,
making.
that's why I'm asking that
Okay,
question.
yeah.
Because I don't necessarily have any issue with the project. But I do have an issue if there's a dispute between the two private entities that will affect what we
Yeah, and is it is it a legitimate argument that it's an expanded use of the easement?
Well, that's
that's-
not before
right.
us. That's gotta be resolved unless there's an agreement.
Yeah,
with
it's
the
just,
project.
is it wise to make a decision? Yeah, where that could lead, I guess, is it responsible to make?
The
one like that?
problem is to get that resolved.
Right,
is
I would
going
agree
to
with that.
take Time.
So to answer that question, I want to think about it for a moment, but I would not, a conditional approval resolving the easement, I would not advise that.
Can we continue,
I don't know.
You can continue it.
the application pending resolution?
Pending resolution.
Yes. You can continue the application pending resolution of a decision or an agreement as to the scope of the.
An agreement and or legal resolution,
Correct.
because that's where it's heading.
Yes.
Do we have the time on it?
Does that extend the time?
He would have, the applicant would have to agree to that, to the extension until resolution of,
And that's Mr. Klein's.
yes.
So you got there's three options. Either we approve the plan, we deny the plan, or we agree to continue pending an ultimate resolution, whether it's by agreement or by court action or whatever legal action there is.
Okay.
Do you have a,
I want it approved.
well, I know that,
The thing is, this board has to make a decision by August 25th.
Mhm.
Unless you agree to the board allowing to continue their decision until that. If you don't want to agree, you don't need to, the board will then render their decision.
and it might not be favorable because of that issue.
Right. I don't understand I can't understand what a continuance would do.
Well, if you so choose, or the churches so choose, there's remedies that can be had to resolve the issue with the scope of the easement.
I will try again.
And so you have the option, either having us vote yes or no, or an agree to and a continue. It's up to you. I'm not pressuring you one.
Nope,
way or- Absolutely not. But some may think that a reasoned approach may be agree to a continuance, and then you can decide how you want to address the issue.
I offered monetary to try and do whatever, and they have no interest in all that. So if 3 out of the other 4 parties and the town is part of the decisions because it's also part of your easement, I don't understand how I could get much more in my favor at this point. There is one.
But you got to resolve that because it runs through there.
Yep.
And so, you say this board approves the development and you begin your construction activities, and the churches believe that it's in violation of that easement, and they institute legal action, and the whole project could be up in smoke, or that could be resolved before you begin and expend that money.
Just, Mr. Chairman. Mary?
Joe?
Mr. Klein, has your attorney seen the memorandum of agreement, the writing?
No, right, that's what I had said. We just got that last week. I had only read that
Can I
part.
make a suggestion that
Please.
you make sure he gets a copy of that?
Yes,
So that he can give you proper legal advice as to what, in fact, avenue you can move forward on.
please.
I would, with that, I would, make a motion to continue this matter to the next, board meeting.
Second.
We want to make sure that we have the timeline.
Yeah, the next board meeting is
Is the 15th, I think.
of August.
And 25 is, August 25 is the date.
So we're in the time.
So that's what we're gonna do. We have a motion, we have a second.
Yep.
All in favor?
Aye.
All not in favor? So you understand what's gonna happen next and
Yes.
if the churches understand what's going to happen next?
So the copy I had was only a one page. If I could just get a copy with there was like a flip page that didn't print.
Mr. Phillips could give me a copy of that.
That's smart. That's prudent.
Getting through again, Joe.
Right? Call in your Jaron Duran.
I'm missing what we marked as town exhibit 1, which is the deed with the easement. Does it?
You just handed that to him, I think.
Yeah, that's what.
No, that's the easement. There was a deed, the deed from the town. No, that's the deed from, that's the title reference from the churches. No, he's copying,
There should be a deed with it.
it's it's a two-page document.
Had it, yeah. Oh, yeah, okay, I know what you're talking about now.
I don't know if you guys took it.
Yeah, let's see here. In your stack there. I do remember that now. Let me look at it, so maybe I have it. Oh, I think it's this. Yeah.
We previously marked this. Michael, you have the original?
Yeah.
Exhibit.
Maybe I have mine next time.
Thank you, Mr. Klein.
Thank you.
Thank you. Thank you. Okay. Next one is Frank Simonelli, 113 Austin Avenue. Oh, I haven't seen Mr. Simonelli here.
Well, those things got high tech now.
Not here.
I don't see it.
Okay, not being here, the matter will pass.
So, do we need to table this?
Well, pass it off the calendar and I think the,
This was certified complete. This application certified complete.
all right.
I thought this was the pre-app.
It's a pre-app.
It's a pre-app.
Yep, so,
Yeah, I mean, I spoke to him this afternoon, so I don't know what the story is, so.
Not here, so it'll pass.
Be here or be square.
Put it on. Yeah. Last but not least. Consider and discuss and act upon 2023 land use legislation and amendments to the zoning ordinance.
Good evening, everyone.
Ashley Sweet is here from Weston and Sampson to review two sections that we're looking at amending due to the changes in the enabling acts. One dealing with adoption and amendments, and then one to our comprehensive permit section. So I'll let Ashley walk you through them, and we can address any questions you might have.
And again, this is just advisory. Ultimately, this goes before the town council.
Recommendation to the town council for adoption would be the appropriate action at the end of this. Okay.
Hello, everyone.
Hello. Long time no see.
Do you have a preference? We can go in order of
Why don't we begin with
adoption.
Article 10.
So we amended this section on the notice and hearing requirements. You can see in section C1, it's where we started. We've amended that section to be consistent with the changes for notice requirements. And this is related to the actual zoning ordinance itself. So this is the notice requirements for an amendment to the zoning ordinance. The big change there, it's not first class. I mean, it's not certified mail, it's first class mail. There's a requirement now that you have to, the town has to post on the website, and that changed general circulation to local circulation. I don't know what the significance of that is, but that was the change they made. And I'm actually noticing in here a couple of edits. So we're going to get rid of or city in line 26. So just read town clerk's office. So you have to post in the clerk's office, one other municipal building, and on the homepage of the website. And then let's see. So then the second one is the changes to the text amendment. Do you have a merger provision? Okay, so we have to address that because you have a merger clause. So that language is also in there. There's some additional language about individuals holding a conservation easement, so that language was added. There's a little bit of renumbering because we added a section, and those are the main changes. Okay, I don't know if anyone has questions.
We're already doing all this stuff, so.
Yeah, it was effective January this year, so it's in effect. We're just making sure your code reflects it properly.
Any questions? Okay, let's move on to Article 12.
Okay. So these are changes to your low to moderate income housing section or your comprehensive permit section. I'm actually noticing right here where it says insert section, we need to fix that. So let me make sure that we take care of that. This is a definition, there's a new definition for what they call an adjustment, which is a new term, which sets it separately from what we would consider now, which is a variance. There's a special term for this now as an adjustment as part of a comprehensive permit. I believe we also added a couple of others. So there was also a change to the definition of infeasible. So we've updated that section. We've added a couple of definitions. We added letter of eligibility. There is a change also to the definition of low to moderate income housing. So we updated that definition also, and I'm noticing grammatical stuff as we go, and I'll assure you that we'll go back and make sure all of those get fixed.
Mr. Chairman, may I ask a question?
Of course.
I understand the definition of infeasible. What is the definition of impracticable?
I mean, my definition could be different than yours. They usually will
Bingo.
be when you're talking about the difference between what the town thinks is impracticable and what a developer might think.
And what one person believes they can do, another person believes they might not be able to do.
Yep,
This is not, well, I'm not getting into philosophy here tonight, but I think that was a wrong road to go anyways. Thank you.
Can I
Yeah,
ask
I-
a question concerning word usage? And I don't know. It just doesn't seem, if I could draw your attention to, on the first page at the bottom, the word infeasible seems to me a little bit vague. It's either unfeasible or feasible or not feasible. I think it's a little clearer that way.
it's a
Who
state,
who
state,
disagrees with me?
it's a state law definition,
This
so we
is,
can't
this is
change
state,
that.
this is again, everything being dictated
Okay.
by the state. So no matter what we say,
It's lawyers again. Right, right.
There's some
To the
pretty
point.
bad grammar in state law, and I don't disagree with you, but
Right.
that's what it is.
there's nothing we, unfortunately, there's nothing we can do.
That's fine.
Yeah, I mean, we're on the back end of this now. These are the ones that you literally have there's no wiggle room here. There's no decision making. We're just going through and making sure that everything is consistent with the state law, even if the state law doesn't entirely make sense.
Yeah, I'm good with it if you're good with it.
Well, I won't say I'm good with it, but I don't know that many are actually good with it, but
Right.
it is what it is.
Mr. Chairman, may I ask a question?
Of course.
The ordinance that we're discussing. It has been modified to make sure that it is in fact, in agreement with state law, the entire document,
This section,
this section.
Mhm.
Okay, so, I mean,
Is there
is there
anything,
any reason why we should waste any more time going through this? If it's already been. Change it. We
So
can't
I'll
change it.
I-
It's a warm summer night.
I hear ya. I do. I hear you. I would say for the purposes of changing anything, no, but maybe for the purposes of talking through it and better understanding the changes and if you have questions about what you're gonna implement it. So
So inconsequential is the right.
We should have a copy of it so that we can implement it, but we're also going to be relying upon your expertise, the expertise of our legal counsel.
Mhm.
Okay, and I would assume the expertise of our planner
sure.
to make sure that in fact, when we take a particular item, it will be in accordance with what that ordinance says. Am I correct?
Yes, the difference is I'm here today and I won't be here tomorrow when you go through an application. So if you have a question that I can help you with, I want to do that when I'm here.
is there any wiggle room in any of, or is
In
all of these changes brought to bring us up to compliance?
The
with-
two in front of you, there's no wiggle room. There was nothing in the comprehensive permit section that gave you flexibility, and there was nothing in the adoption and amendment section that would have permitted you to have any discretion.
Okay, Mr. Chairman, I would make a motion that we approve both the ordinances that are before us. In addition to that, that each board member receive a copy of these ordinances for their perusal and reference in the future.
In not only these two, but a copy of the updated, completed ordinances would be helpful. For for the
When we
board.
Get there.
So I will say there, you don't have discretion in terms of what we have to put in here, but I'll give you an example. And I apologize, this one doesn't have line numbers, but on page 3, the last definition that you had in there, number 12, was administrative officer. We actually struck that definition because it's defined in your zoning ordinance. And if you ever were to change it, you'd have kind of dueling definitions. There's no reason for you to define it in this particular section and also in the definition portion of,
That's Mike.
unless your solicitor disagrees, but that was the approach we took
I think
there.
that's
Your,
the
your
approach we did.
administrative officer is already defined. We didn't want to see dueling, definitions.
Anything else like that in the document?
Let me run through quickly.
It's a warm summer night. And I'm about it. Somebody needs to second my motion. Second.
Well, let's just wait and see if there's any. She took the time to come here today.
The density provisions are not discussed. You can't do anything. The process, you can't do anything. Submission requirements are, those are entered as what is required by state law, and then that would be on top of your local requirements, so that there's nothing there to change. I don't think there's anything else.
So we had a second?
No, there was no second.
Okay. Al gave a
That
second.
was a delayed second.
Is it an official second now?
Yes, sir.
Okay. All in favor? Aye. All not in favor? The ayes have it. And that being the last matter before the board today, do we have a motion?
Motion to adjourn.
Wait, did you want to discuss special use permits, or is that not on there? It's not. Okay.
Thinking it's inconsequential is the word.
Yes.
Okay.
Mr. Moan?
Before we act on that motion, I just wanted to bring a couple of, I recall discussing these, when you were here, the last, half dozen times. On our page 5, on the first paragraph, 12A, 1, pre-application conference may be required by the administrative officer or planning board or requested by the applicant. The pre-application conference may be with the planning board, technical review committee, or administrative officer as determined by the administrative officer. Then you go to, I just want the board to be aware of this, because Michael may be in Tahiti 6 months from now, and we may be looking to hire you. But
If he's going to Tahiti, I'm going too.
okay, so then going over to my page 9, under the final review. Decision on a final plan, an application filed in accordance with this article shall be approved by the administrative officer unless such application does not satisfy conditions set forth in the preliminary plan approval decision, or such application does not have. So these are going to the administrative officer. I mean, they're pipelined, unless there's a clause in the preliminary that could short circuit it. But once everybody's cool with this, these are approved by the administrative office.
Well, the yeah, the final is, the preliminary plan still comes to you. Master plan doesn't exist anymore.
That's right. So then the last thing I wanted to talk about was where they list the different things that the board can stand on if issuing a denial. And one of them is environmental. wasn't that,
They took
wasn't
that,
that, altered or removed?
they took it out.
Yeah,
They took it out.
no more significant environmental impact.
Yep,
Well,
it's gone.
It's a little different, meaning that they don't need to certify that there's no environmental impact in terms of the applicant.
It means that that's not a finding for
Yeah.
you.
So if there's an environmental impact that we, I'm not quite sure I agree with that. If I recall, we had a meeting with the town council probably a year ago.
I know what you're talking about.
And this topic came up.
Yep.
And if I recall how it was brought out as part of the application, there was a prior requirement where the applicant had to certify as part of the project that there was no detrimental environmental impact. That was, the discussion was that was going to be taken out, but that does not necessarily prevent the board ultimately finding if truly there is an environmental impact, that it could affect how the board looks at it. That's,
So that's not,
That's
no. Well, so that's, my experience is not that anyone has to certify anything.
even way prior to all these changes over the last year.
So-
That's how it was brought out at, we had someone came to give us an overview, right?
Yeah.
Uh, Yeah, no, we just had, I was there, Ray Malone was there.
Right, but I thought there was some.
The whole finding is gone.
Yes.
The whole finding
Whole
is
finding is
gone.
gone.
There will be no significant negative environmental impacts from the proposed development as shown on the final plan with all required conditions for approval is struck. It's gone.
It was in the zoning section.
What,
We were
No,
discussing.
I thought it was in our findings, like we should have those
It is.
7 findings. That one was taken out.
finding is gone.
It's gone. That's how I.
So what happens if there is one that,
So I'm looking at page 10 and 11.
because you could have one that really, an oil issue. We had before us other issues that raise concerns to the board about environmental impact.
I'm looking on page 10 and 11 under required findings. Our page 10 and 11, and, let's see, on number, it's renumbered 4, there will be no significant negative impacts on the health and safety of current or future residents. And then down below, required findings for denial.
Impact drafting is not.
Concerns for environment and health and safety of current residents have not been adequately addressed. So is that how we're dealing with this? Okay, just wanted to
Yeah.
make sure everybody, you know.
What page
was
is
in
that
here.
on again, Michael? What page?
Clarify, are these standards? that they're
Michael.
looking at?
What page are you?
Those are specific
11.
to a comprehensive permit. Those are only for a comp permit.
Not for your other.
No,
Well, it says
understand
it's
that.
required findings. That doesn't mean you can't make other findings.
That's true. We are intelligent beings, aren't we, Counselor?
Yes.
So,
Okay, thank you. I won't hold up that motion now.
we have a second?
Second.
All in favor? Aye.
Aye.
All not in favor? The ayes have it. Who is taking the exhibits, Michael?